Hello and welcome to this episode of Law for Lawmakers. I'm Fiona Rutherford, Chief Executive of Justice, and we're a law reform and human rights charity working to create a fairer justice system within everyone's reach. This podcast is based on our Law for Lawmakers guide, which helps repair the cracks in the UK's political infrastructure by giving every MP the tools they need to act as custodians of our democracy. The podcast will explain key legal and constitutional principles to help politicians of all parties and their staff review new laws, table and write amendments to bills, support their constituents, and much more. But this podcast isn't just for parliamentarians, it's for anyone who cares about how laws are made and upheld. Each episode brings together leading voices from law politics and public life to explore the legal principles that underpin our democracy and explain how Parliament can help to uphold them. In this episode, we're going to be looking at the rule of law. The rule of law is a cornerstone of the UK's constitution, and it's a central theme in Justice's Law for Lawmakers guide. The rule of law isn't just a legal concept, it's what protects our rights, keeps government powers in check, and ensures fairness in everyday life. And whether you're challenging a housing decision, seeking justice after a crime, or simply trying to understand your rights, the rule of law is what makes that possible. To explore the rule of law, I'm joined by someone whose career spans the courtroom, Parliament, and the heart of our constitutional debates. The Right Honourable Sir Robert Buckland KBE has enjoyed a distinguished career in law and politics. He's a practising barrister, a senior counsellor and head of policy at Payne Hicks Beach, and serves as the third Church Estates Commissioner, overseeing some of the Church of England's most historic buildings and its net zero strategy. Before returning to legal practice, Sir Robert spent 14 years in Parliament as the MP for South Swindon, serving in the governments of 4 Prime Ministers. He's held senior roles including Solicitor General, Minister of State for Justice, and the Lord Chancellor and Secretary of State for Justice. He later returned to Cabinet as Secretary of State for Wales and chaired the Northern Ireland Affairs Select Committee. He's a passionate advocate for criminal law reform, for disability rights and autism inclusion, having recently led an independent review into autism and employment. And he also writes and lectures widely on constitutional law and political history and was a senior fellow at Harvard Kennedy School. Sir Robert, welcome. So Robert, today I'd like to focus in on the rule of law. I'm going to start by asking you about how we define it. You've had some of the most senior legal roles in government. How has your understanding of the rule of law evolved during your time in those roles?
Well, having given a lot of thought to this well-used, sometimes overused phrase, I think we need to first of all remember that it's not the law itself. It is, in fact, a political construct, a very important political construct. It helps underpin what it means to live in a free society where we are all treated equally, and where if we are prosecuted or brought to justice, or if we seek justice, we can do so via an independent judiciary with independent legal representation. That's really at the heart of it. But it's also the other side of a very important political coin, which is democracy itself, the sovereignty of our Parliament, that is the embodiment of democracy here in the UK. And that, of course, applies to all the 3 jurisdictions within our country. And therefore, although, in recent years there have been a lot of perceived tensions between those who uphold the rule of law and those who believe that parliamentary sovereignty trumps everything, the truth is that without one, the other cannot exist, and vice versa. And I can't emphasise this more clearly. It's time that we moved away from that binary debate and actually realised that what we're talking about are 2 sides of the same coin.
So one of the biggest speakers or authors, I suppose, of the rule of law is often referred to as Judge Bingham, Lord Bingham. And his, I suppose, version in relation to or interpretation of the rule of law would not, I suppose, agree with the political construct point that you've just raised, but would absolutely be on all fours with your point about the role it plays in a fair and open democracy. In relation to that, what does the rule of law mean in practice, though, on that first point for parliamentarians? What does it mean for them? How do they need to ensure that they understand it and implement it appropriately?
Well, first of all, parliamentarians are lawmakers. They are absolutely at the heart of the process by which we make most modern law. The common law, of course, is a huge part of our system and our continuing tradition and the evolution of the law. But statute law has become more and more important as Parliament passes legislation to deal with a complex society with increasingly demanding regulatory structures and the sheer range of different issues that politicians have to deal with right across our society. And therefore, remembering that lawmaking function and the serious responsibility that that brings, I think is something that sometimes, my former colleagues need a bit more reminding of. And I think, one of the main sort of practical roles that organisations like Justice can have is to help parliamentarians, to equip them with the tools that they need in order to become effective lawmakers and scrutineers of law.
Well, thank you for mentioning that, Sir Robert. You'll be aware of our Law for Lawmakers guide, which this podcast is very much founded on. So we very much hope that both this podcast and the guide will help with that suggestion there. Talking about the legal certainty element that's often talked about when discussing the rule of law, how does legal certainty and access to justice underpin that democratic governance?
Well, legal certainty, I've got a fairly ordered mind, and legal certainty always appeals to the ordered mind. But it's not just a question of making things neat and tidy and accessible. It's actually fundamental, first of all, to that question of access to justice. If you don't know where the law is, if the law is obscure, unclear and uncodified in many respects, then it soon falls into disrepute and it becomes a thing that is remote and inaccessible and exactly the opposite of what good law should be. But secondly, there is a vital economic aspect to all of this, which is often overlooked. It's not just about the lawyers. The law is not there for the lawyers. Rule of law is not about rule of lawyers, nor should it ever be. It's about a society that is open, that is free, that is democratic, but where you can also invest safely. If you want to be an investor into our country, you want to know that you've got, if there's a problem, an independent judiciary and a legal system and a legal profession that can represent your interests in order to seek redress of grievance. It is no coincidence that the United Kingdom is one of the biggest economies in the world and also enjoys a virtually unrivaled rule of law reputation. The two go hand in hand. And simply, it's about the wealth of future generations and the economic wealth of this country that I think we should be absolutely placing rule of law issues front and centre in.
Well, I certainly agree with that. And I suppose that perhaps we will move on shortly to talk about the European Convention of Human Rights and the implications, I think, of some of the suggestions that are being discussed at the moment in terms of leaving or staying. Because I think that point you make around the economy or the international standing is there may be some similarities or some parallels with that, but I won't put words in your mouth in relation to that. I just want to say one little thing about, you mentioned judicial independence. I would entirely agree is absolutely fundamental to the definition of the rule of law. And ask you, what are the risks when political rhetoric undermines the judiciary or undermines that judicial independence?
I think there are huge risks, and we saw it with enemies of the people nearly 10 years ago. We're seeing an increasing naming of judges, individual judges, which I think is leading not just to security concerns, but also real fears amongst the judiciary that they are becoming the targets of ire and opprobrium, and their job is that their working life is no longer a safe one. And this is crazy. Judges are men and women who are sent there to do an important public service. They're not always going to get it right. That's why we've got an appeals system. But their judgments are their public utterances. They can't come back and employ a press agent, a media agent to go out and defend their cause. They've made their comment, they've made their statement through their judgments, and they're not able to defend themselves in the way that perhaps a media celebrity or a politician would be, which is why those who are then given the responsibility of defending the judiciary's interests, the Lord Chancellor, law officers have a role obviously in helping with the legal education and that sense of comity. They have a particular role which I undertook for several years, to make it very clear that when attacks like that happen, it's just not acceptable, and that politicians have a particular responsibility to couch their remarks much more carefully. Now, that's not to say that, judges should be bowed down and revered. Of course, you can be critical of judgments. I myself have been critical of a number of judgments of the Court of Appeal or the Supreme Court. But it's the way in which it is done that is as important as the fact of the comment itself. And I think there's been too much fast and loose language of late, not just from one side, not just from the opposition, but also sometimes from government itself, which I think should cause people to pause for thought and to reflect about the wisdom or otherwise of their actions.
Well, it's definitely something we agree on entirely on that point. I mentioned or hinted that we would move on to speak about the European Convention of Human Rights, and you've mentioned your recent or fairly recent role as Lord Chancellor, which in that role you commissioned the independent review of the Human Rights Act, which in essence found that it was always working well. I'm summarising obviously a very, very long report. But Sir Peter Gross, who chaired that independent review, published his report in December 2021, and there have been increasing discussions surrounding moves to leave the convention since that date, maybe shortly thereafter, including the government's announcement this weekend that the policy is to withdraw. How and why have things changed since then, since 2021?
I think the increasing pressure and concern about migration, in particular illegal migration and small boats crossings, has fueled this debate and has now, in the minds of some of my former colleagues, turned them against the convention. I understand the frustration. I wrestled in government with these issues and was jointly responsible for legislation such as the Immigration and Borders Bill of 2022, which tightened the rules and was seen as quite a draconian approach. I make no apology for it. It was absolutely the right thing to do. But both the then Home Secretary and I felt that we could operate within the purview of the European Convention. We did not see a need to withdraw. I am still not persuaded of the need to withdraw. The review that I commissioned from Sir Peter was carefully geographically balanced. We had academics from the south of Ireland and we had Baroness Alone from the north, a very experienced lawyer and public servant, to really get to the UK dimension of the ECHR, which far too many of my colleagues who look at things from an England viewpoint miss. And I think that dimension, and particularly the Northern Ireland dimension after Brexit, and the Good Friday settlement and the political realities of the divided communities there and the lack of shared faith in our police and security services, mean that you tamper with membership at your peril if you really believe in the United Kingdom. And had I stayed as Lord Chancellor, I would have probably gone beyond Gross. I do think there is more we can do to make the Human Rights Act clearer for judges, to stop an overly slavish approach to adopting case law from Strasbourg. I don't want that for Britain. We have a margin of appreciation. Some of the Strasbourg case law, for example, on climate change, is just bats. And that's not just me. That was our English judge, a British judge, Tim Ike, who issued a dissenting opinion. Of course, he was far more diplomatic in his language as you'd expect a distinguished lawyer like Tim to be. But I want us to be able to diverge from some of that case law rather than slavishly following it. And I think that the Human Rights Act needs tweaking to make that crystal clear. I also don't like the read-down provisions in Section 3. I'd get rid of that. I don't think judges are in a comfortable place when they're being asked to read down legislation. Declarations of incompatibility, yes, but let Parliament get on with that job. And this is, I think, where the tension lies and where certainly I, as a Conservative lawyer, feel very strongly that whilst, I respect the line of thinking of Lord Bingham and others, I'm not fully in agreement with it, because I do not think that our Constitution should ever be described as a separation of powers one. It is not. It is a checks and balances Constitution, fundamentally different, within which we have a robustly independent judiciary. And I think that looking at other members of the Convention, and particularly on the immigration issue, you're not hearing about withdrawal from Germany or Denmark or Greece, who have domestic laws that allow them to deport illegal migrants. I think a lot of the issues that certainly my party think lie at the door of the European Convention actually lie somewhere else altogether. And to cut a long story short, I think the withdrawal question is just a massive red herring that should be avoided.
You started on migration, Sir Robert, and we all know that that's one area where the UK is very rarely overturned or has cases found against it in the Strasbourg court. So your description of red herring would seem certainly to fit that point. You mentioned, however, Northern Ireland, and of course you were the chair of the Northern Ireland Committee, and you conducted an inquiry into the impact of withdrawing from the Convention on Northern Ireland, something you spoke about a moment ago. Something you said then, I think, that was often overlooked in debates around this particular issue. What were the findings of that inquiry, Robert? I know you wrote a letter, but maybe you could just say a bit more about that.
We did. We were cut short by the election. We would have produced a full report, but instead we produced a letter which was sent to the then Secretary of State that outlines some of the real practical pitfalls that we think would beset Northern Ireland if there was a withdrawal by that part of the island of Ireland from the Convention. They really relate to police and security cooperation cross-border. I think that it would be much more difficult for the Garda and the security forces in the south to work with the PSNI and security forces in the north on joint investigatory matters if Britain left the Convention. It's a very, I think, graphic illustration of an overall problem I think there'd be with criminal justice cooperation if we withdrew wholesale from the Convention. And there's suddenly a huge mismatch between our position and the position of other European countries. So that's one major problem. I also think there would be problems with the EU trade and cooperation agreement. I think that underpinning a lot of the TCA that was agreed at the time of Brexit is the shared commitment to Britain's membership of the European Convention. And whilst it's not impossible to try and weave your way out of it, it's going to take a huge amount of time and could cause instability in a very important agreement. And of course that leads me on to the protocol. The protocol in Article 2 says there shall be no diminution of existing rights. I disagree with people who seem to think that you can separate out the ECHR rights from EU law. I don't think you can. Yes, they're separate sources of law, but I think that the intention of the authors of that document was very, very clear. And again, what you're doing is it's not legally impossible to do this, but you're pulling at threads that start to unravel and start to create a whole host of problems that you really do not want to see in the first place. And ultimately, as a believer in the Union and a believer that Northern Ireland should be part of the UK, I don't want to do anything that in effect promotes or provokes a border poll, a vote on membership of the United Kingdom that could very well see Northern Ireland slip away from the UK. And I think this is what I call the sort of British dimension of membership of the ECHR that is often overlooked by my colleagues who focus purely on the migration issue.
Thank you so much for expanding on that, because I think it is really helpful that people do understand the different dimensions that sit behind, or the different implications, let's put it that way, that sit behind a sentence that's all too easy to say, but actually, as you are making very clear, very difficult to deliver on, and big question is whether you actually really intend to do some of those other the other consequences that sit with.
You're right, Fiona. Because the other thing is that this process takes years. You don't just withdraw in 5 minutes. It'll make the Article 50 process look like a walk in the park. And if you think that withdrawal is going to solve the here and now issues of legal migration, what planet are you on? It's a totally the wrong answer to the undeniable problem that we have about illegal migration and the pressure it's causing on some of our communities and the anger that it's causing amongst the population who want to see the enforcement of rules, quite rightly. And, why is it that lots of people are really cheesed off and hacked off with the situation? It's because they're not seeing the law applied equally and fairly as they should have a right to as British citizens. So it does come back, this argument does come back to the fundamental, belief in fairness and justice that I think the British people absolutely want to see.
You're sort of, I think, touching on it now, but what would you like to say a little bit more about what the implications would be to the rule of law on leaving the convention if that were to happen?
Well, I think it would send a message to the rest of the world that once again Britain instead of being out there and leading and being a part of the international community, wants to withdraw from things. Instead of staying and fighting its corner and arguing the case on things like the Refugee Convention, for example, and the undoubted problem with refoulement, it needs to be reformed. It's out of date. It doesn't take into account the passage of people through many safe countries. Instead of engaging and saying, right, what we need is international leadership and a coordinated approach to the care of asylum seekers and migrants, quietly and silently walking to the door and then leaving the room is exactly the wrong answer to the question. What else are we going to leave next? Well, the International Criminal Court, the UN. Are we going to leave the world? It is not British. Our tradition is to get involved and to lead. And it is no coincidence that Britain, as one of the largest economies in the world, with a global reach, with a defence and security series of obligations, is made stronger by our membership of international institutions, not weaker. And that's why I find this argument wholly flawed.
So what would your advice be, as someone who served as Lord Chancellor, to parliamentarians who are navigating this issue now, this debate? What would you say?
I'd say look at the facts. Look at the vanishingly small number of times the UK is in breach of convention rights. Look at that study done by Oxford University this week, which I think showed since 1980 on privacy and Article 8 rights, immigration-related cases. I think there have been 3 occasions in 45 years the United Kingdom has been found in breach. And physician, heal thyself. Let's sort out the domestic law. The immigration rules are in a mess. I'm tempted to run them through ChatGPT 5 and see what we can come up with. We've got to do better than this. We've got to codify our rules, remember the purpose behind which these rules were devised, and create a system that isn't such a legal labyrinth where first-tier tribunal judges are having to spend hours working their way through, and then lots of points are having to be taken to appeal. This is why the immigration system is falling down. This is one of the reasons, I think, for the delay, as well as the resourcing issues in the Home Office. And frankly, a simpler, clearer, codified system would, I think, go a long way to help deal with the current crisis that we undoubtedly have in the handling of migration cases.
I could continue, and I suspect you could, talking about this for some time, but you mentioned ChatGPT, and AI I know is an area of focus for you, particularly over the last year or two with your connections to Harvard, and as well that Justice recently published a report on AI in the justice system. How can we ensure that Parliament supports innovation rather than undermines the rule of law?
I think that it's a constant question of focus. Parliamentarians, I know from my own 15 years in the House, are going to be diverted by many, many calls on their time. The pressure of constituency work, the unremitting glare of the media, the calls of the whips, the sheer variety of situations and obligations that you have. And they are, I think, in some respects, and their offices can be forgiven for, always being like the white rabbit, always in a rush, looking at the clock. And I think it's the job for charities and organisations like Justice to give them the support and the thought space to say, look, it doesn't need to be like this. It's not a constant battle between Parliament and the judges. The whole system was designed to, yes, have some tensions in it. Of course, there are going to be tensions and differences, but there was that essential mutual respect between the different arms of the Constitution that meant that we understood each other and knew whose territory we were operating on. And that applies as much to the judiciary as it does to parliamentarians, which is why I think the recent turn of the Supreme Court in cases like Ellen Kane, moving away from lines of authority that I thought were starting to lead to the substitution by senior judges of moral judgment on issues rather than actually legal judgment, I think has been a very welcome thing and perhaps isn't fully understood by parliamentarians as it should be. I did a number of lectures on this when I was Lord Chancellor, and I think that we need to, in words of simple language, clear language, explain that far from this being a judiciary that wants to accrue power and to seep into all aspects of political life, wants to, in the finest traditions of the judiciary of this country, stay as far away as possible from politics and to answer the questions that they are asked, either in the reference to the Supreme Court or in the grounds of appeal that the Court of Appeal will be considering. Let's all just remember that, shall we? Let's get back to those principles. And I think, we can start to stop this sort of Matthew Arnold, ignorant armies clashing by night scenario that I think often applies to the diverging worlds of law and politics.
Well, we know, speaking of the judiciary, that they and AI, that the judiciary have taken some strides towards setting out some guidance as to how it's expected to be used in the courtroom. With the parliamentarian or parliament in mind, what safeguards do you think should be in place when deploying AI legal decision making? What do we need to think about?
I actually think that now is the time, and we're already seeing this in the professions and the judiciary, to really develop some ethical safeguards and principles, whether it's things like explicability, challengeability, what I call algorithmic humility, a sense that we're able to, through ethics boards and joint technical legal committees, oversee the safe use of AI in the system so that there isn't the sort of mission creep or technological blindness that, for example, gave us the Horizons post office scandal, or which has definitely affected parts of the single justice procedure, where, people whose written submissions into the procedure have been ignored. The warnings from previous technology are all there. And instead of being mesmerised by AI and the tech, what we can do as ethicists, which is what lawyers are, is to set out some principles. And I'll be talking about that more in a few days' time at Inner Temple. So if you're really excited and interested, then come along and listen to what I've got to say about all these principles that I think we can apply fairly swiftly.
Well, I am very much excited about the potential of AI, and justice, of course, is trying to work out frameworks to some extent with your help as well, Robert. So I'm a member of Inner Temple, so I should probably find myself there in a few nights' time to come and listen. In closing, Robert, I wonder, thinking about new parliamentarians, and of course we've had a first year of, or just over a year of new Westminster parliamentarians, but we've got a Scottish Parliament election next year, and the year after that, Northern Ireland, all being well. What advice would you give to new parliamentarians about engaging with legal issues and understanding the rule of law?
Well, first of all, I'd say to all my colleagues and erstwhile colleagues is, you don't have to be a lawyer to care about the law. In fact, the law's for all of us. It's not just for the lawyers, and my goodness me, if we just left it to the lawyers, we would be in a pretty pickle, despite their best intentions. They are lawmakers in all these bodies. They have responsibilities to learn a bit more about that process. And you don't have to be a legal expert to understand the meaning of words or the purpose of legislation. You don't have to be a lawyer to table amendments and to get to grips with the scrutiny of a bill. Some of the most impressive people I've worked with in the Commons were nowhere near the law, but they understood their subject areas, and they understood that with poor policy would often result in poor legislation. And that's why I think the focus there has to be on the development of good, clear policy, which then can inform the draftsmen and women in their work. And that's why I think that this is too important for the lawyers. And so to all the new recruits, all the new arrivals in the Senedd or in the Scottish Parliament, get involved and don't leave the law to others.
Senedd, I forgot that too. I absolutely should have mentioned the Senedd elections as well. So thank you for mentioning that. A final question. What gives you hope about the future of the rule of law in the UK, Robert?
I think what gives me hope is actually the dawn of the new technology that we have, because far from being a skeptic, I think that the use of AI, the ethical use of AI, with the right tramlines and the right guardrails, with the right data sets, will really empower ordinary people to seek early solutions to their problems. So I want to see a world where, rather than people having to come to court to fight their possession claim, that the problem's been sorted out way before that because of some simple answers to questions that they may have been too scared to ask. And that will apply in terms of benefit rights claims. It will apply in terms of a whole plethora of consumer-related rights that people at the moment just don't have the wherewithal to be able to assert. I think that, the safe use of this technology is going to give people the confidence that they deserve to have in order to do that diverting work. As you know, as a big champion of public legal education, I think the technology that we now have make justice and law accessible in a way that we could have only dreamed about. And this is the true public legal education that I think organisations like Justice can really help steer and steward so that we make access to justice a reality for millions of more people.
Thank you, Sir Robert, for sharing your insights and experience. The rule of law is often spoken about, but rarely is it unpacked with such clarity and passion. So thank you for your time. And thank you for listening to Law for Lawmakers. For parliamentarians, understanding legal and constitutional principles is essential to shaping fair and effective laws. But these principles matter to all of us. They protect our rights, they hold power to account, and ensure justice is within reach for everyone. Justice is a cross-party law reform and human rights charity working to build a justice system that is fair, accessible, and rooted in the rule of law. Our Law for Lawmakers guide is designed to support MPs, peers, and their staff in navigating complex legal issues, scrutinising legislation, and standing up for their constituents. To learn more about our work and to access the guide, visit www.justice.org.uk. And if you found this episode insightful, like, subscribe, and share it with your colleagues and friends who care about the future of our justice system. I look forward to speaking to you on the next episode.